In the previous lecture, we discussed consequentialist arguments for abolition, arguments that were premised on denying marginal deterrence. Today we'll discuss many other moral arguments for abolition, concluding with the only argument that's been accepted by a majority of the U.S. Supreme Court, the argument from arbitrariness or caprice. The first argument proceeds from an absolute moral prohibition on homicide. In the King James Bible, the Ten Commandments state, "Thou shalt not kill." This could be read uncharitably as an absolute prohibition. In fact, no major world religion or legal system accepts an absolute prohibition on homicide. It's widely seen as permissible to kill someone who poses an imminent threat of death or serious bodily harm to someone else. Many believe that killing in a just war is also permissible. Some accept mercy killing, also called euthanasia. Nevertheless, someone who accepts an absolute moral prohibition on homicide must favor abolition, and can do so without contradicting herself. This actual bumper sticker suggests a popular abolitionist argument. The idea is that executing murderers is inconsistent or hypocritical because it amounts to killing someone in order to demonstrate that killing is wrong. There are two flaws in this argument. First, no legal system implies that all homicides are wrong. Unjustified homicides are wrong, but some homicides are justified, as noted earlier. Retentionists believe that executing a convicted murderer who received a fair trial is, at least sometimes, also a justified homicide. Abolitionists disagree, of course, but they can't make their case simply by observing that execution is a homicide. The second problem with the argument is that it fails to recognize the moral difference between the state and a private individual. The state does many things to us that we must not do to each other. The state forces us to give up our money when it taxes us. Private citizens who do so commit theft and other crimes. The state confines prison inmates against their will. Private citizens who do so are kidnappers. The point is that there are types of action that are impermissible when a private citizen performs them, but permissible when the state does so. The state's position is not hypocritical. Here's a more carefully stated abolitionist premise. It's wrong to kill an individual who poses no imminent threat to anyone else. This might be true. If so, then the abolitionist can consistently make her argument. But retentionists suggest a qualification. It's wrong to kill an innocent individual who poses no imminent threat. Murderers aren't innocent, so retentionism is an equally consistent position on this premise. Some abolitionists accept the retentionist qualification and the claim that murderers deserve to die as a moral matter. They claim that nonetheless the state shouldn't execute murderers because doing so is inhumane. Executing someone, they contend, is just too terrible. An inmate on death row suffers great emotional distress as his execution date approaches. It's inhumane to inflict such distress, even on those who deserve it. A slightly different abolitionist argument assumes that the state as such operates under special moral restrictions. This argument appears in your assigned reading by Jeffrey Ryman. Abolitionists such as Ryman argue that it's uncivilized for the state to kill someone who poses no imminent threat. Part of the meaning of civilization is that the state limits its use of violence to protective purposes. Civilized states don't use violence just because someone deserves it. This is why civilized states don't use corporal punishment or torture. Surely such punishments are sometimes deserved, but civilized states never stoop so low. Police are legally permitted to injure suspects for defensive and subduing purposes, but not for punitive purposes. Prison inmates often sustain injuries, but the law doesn't authorize the state to injure them, and it actually requires the state to provide them with medical care. Most of the civilized world has abolished capital punishment. Death is the only remaining punishment in the United States in which the state deliberately inflicts physical damage on the convict's body as a form of punishment. This unique attribute is enough to convince many abolitionists that capital punishment is uncivilized, just as torture is. The next abolitionist argument is the argument from mistaken conviction. Conviction of the innocent is a terrible injustice. In recent years, DNA evidence has exonerated convicted criminals in widely publicized cases. Some abolitionists argue that capital punishment should be abolished because we can't eliminate the possibility of executing an innocent convict. This argument must be made carefully. No criminal justice system can eliminate the possibility of wrongful convictions. Wrongful convictions are, if anything, less common in capital cases than in others. Abolitionists don't favor abolishing other punishments just because mistakes are inevitable, so they need a reason to single out capital punishment. They could point out that some punishments are necessary for crime control purposes, whereas capital punishment is unnecessary. But this is really a consequentialist argument. Instead, abolitionists emphasize that execution is irrevocable. Dead people can't be brought back to life. We should abolish the death penalty so the state never makes the mistake of executing an innocent person. An innocent prisoner at least has a chance for exoneration while he lives. The problem with this argument is that incarcerating an innocent person is also a terrible mistake, more terrible the longer his sentence. True, incarcerating an innocent person is not as terrible as executing him, and an inmate can work to prove his innocence. But incarcerating an innocent person is still terribly unjust. Even if he's ultimately exonerated and released, he'll never receive full compensation for his years of lost freedom. Yet abolitionists don't favor eliminating incarceration altogether, just because thousands of innocent convicts languish in prison today. Again, the abolitionist can argue that eliminating incarceration would have disastrous social consequences, whereas eliminating the death penalty would not. But again, this is a consequentialist argument, not actually an argument from mistake. Of all the arguments against the death penalty, only one has ever been accepted by a majority of the U.S. Supreme Court, and it's not really an argument against the death penalty per se. It's the argument from caprice, also known as arbitrariness. The argument goes like this. If those convicted of capital crimes are selected for execution on a morally arbitrary basis, then executions must end. In the USA, those convicted of capital crimes are selected for execution on a morally arbitrary basis. Therefore, executions in the USA must end. In the United States, murder defendants have a constitutional right to a jury trial, which they almost always request. The jury determines whether the facts of the case warrant a conviction. If the prosecution seeks the death penalty, then the jury is also charged with deciding whether to sentence the convict to death. Prosecutors in death penalty states prosecute thousands of cases of first-degree murder every year, but they seek the death penalty in only a tiny fraction of those cases. Juries in capital cases render thousands of convictions for first-degree murder every year, but they sentence only a tiny fraction of those convicts to death. Abolitionists argue that this unlucky fraction is selected for death on a morally arbitrary basis, virtually at random. You'd think that the very worst murderers would be the ones singled out for execution. But in fact, no one's been able to demonstrate that the murderers who are executed are on average more deserving of death than those who are allowed to live. Brutal, sadistic murderers go to prison, while much less culpable murderers in the same state are executed. This isn't to say that the executed murderers don't deserve to die. That would be a different argument. The objection here is based on comparative justice. Morally similar cases should be treated similarly. It's especially unfair when a less culpable convict is treated more harshly than someone more culpable. Add to this the fact that one of the two is actually being executed rather than incarcerated, which is a difference of kind, not just degree. As I mentioned, the caprice argument is not an argument against capital punishment as such. It's an argument against the imperfect administration of capital punishment in actual legal systems such as the United States, in which a small, unlucky subset of those who deserve death are actually executed, for reasons unrelated to their relative desert. The argument from caprice has its critics, such as Ernest Vandenhoegh, whose paper you were assigned. Retentionists such as Vandenhoegh make several points. Some deny that it's unjust to execute a murderer who deserves to die, just because some other murderer who escapes execution is equally or more deserving of death. The only question of justice, they claim, is whether the murderer himself deserves to die. If he does, then executing him isn't unjust. How others are treated is irrelevant. Critics also note that caprice pervades the criminal justice system, not just the death penalty system. A wide range of random factors determine who's arrested, charged, prosecuted, convicted, and sentenced for crimes. Many prison inmates are much less deserving of punishment than individuals still roaming the streets. We shouldn't release these inmates for the sake of comparative justice, nor should we abolish the death penalty. The defender of the caprice argument counters that the injustice is more pronounced in the case of the death penalty because the penalty is more severe. Also, the state should take whatever reasonable steps it can to minimize violations of comparative justice, even if it can't eradicate such injustices. Eliminating caprice by abolishing capital punishment has fewer social costs than eliminating other violations of comparative justice. In the early 1970s, the caprice argument persuaded a majority of the justices on the Supreme Court of the United States. At that time, juries in death penalty states were asked to reach a verdict and also to decide the sentence. Juries weren't told on what basis to make their sentencing decisions, and they weren't asked to justify their decisions to the judge or the public. They had what's called unguided discretion in capital sentencing. This became a sticking point for the court in a 1973 case called Furman v. Georgia that you were assigned. Much of your assigned reading is from Justice William Brennan's opinion, in which he rehearses several abolitionist arguments that we've already discussed. However, Brennan's opinion isn't the opinion of the court. The only argument that's endorsed by a majority of the court is the caprice argument, advanced in Brennan's opinion and the opinion of Justice Potter Stewart, that's also included in the reading. Stewart notes how extraordinarily rare it is for juries to impose a death sentence relative to how often they're empowered to do so. He describes the infrequency of execution as wanton and freakish. That alone convinces him that the death penalty is imposed arbitrarily when it is imposed. The Furman ruling effectively began a moratorium on capital punishment in the United States that lasted from 1973 until 1976. Every death penalty state halted executions because every state used a system of unguided jury discretion similar to the Georgia system that the court had invalidated. But the states proceeded to revise their death penalty statutes. Georgia, in particular, replaced its system of unguided discretion with a new system of guided discretion. In the new system, after reaching a guilty verdict in a capital case, juries in Georgia began a separate sentencing phase. They were instructed to determine if any aggravating or mitigating factors were present. They were required to state which factors, if any, they found. Only if the jury found one or more aggravating factors were they then authorized to impose a death sentence. Even then, they weren't required to do so. The new system was again challenged in the 1976 case of Gregg v. Georgia, which you were also assigned to read. The Supreme Court in Gregg examined the new guided discretion system and concluded that the risk of arbitrary infliction had been reduced to acceptable levels. The death penalty moratorium was over. Subsequent commentators have questioned whether the new system that all death penalty states have now adopted has really addressed the problem of caprice. In the next lecture, we'll consider a particularly disturbing form of caprice in which racial bias is said to play a role.